I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into compilation 143, and we will be in two different courtrooms for this compilation. Before I give you the rundown on those courtrooms, just know that there will be chapters added for your convenience. Also, commentary will be left in these proceedings for these two different judges' courtrooms. Also, don't forget to like, comment, share, and subscribe. And now let me give you the rundown of the courtrooms that we will be in on today. First, we will be in the courtroom of Judge Warren Davis out of the state of Georgia. And second, we will be covering a sovereign citizen who we've covered here multiple times on the channel, and I should have did like a compilation with all of his proceedings, but I just added one of his proceedings into this compilation on today by the name of Mr. Muhammad, and that is going to be out of the state of Washington in the Thurston County District Court. Guys, these compilations are going well. We're having a lot of fun with these, and we're going to continue to do so. So without further ado, guys, let's go ahead and jump into number 143.
All right, then we will go to Ms. Celestine's case. We will let the state be able to set up. There's very important issues today. Now, we were on this, well, just set the case up, and then it's back to me.
All right. 23B 1593 etched in.
Okay. All right. Ms. Celestine, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Ms. Celestine would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant. Therefore, the bench warrant was resolved. Her prior examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the bond.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in Ellen the bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant. And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol, and that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state arrest made that was September 16th, 2025.
Right? So after the time she failed to appear in the court, did she have any other arrests other than this driving offense?
Not that I'm aware of.
Okay.
And so it wasn't until this arrest by Georgia State Patrol that they discovered the benchmark was unstable. So we would submit to the court that based on the defendant's own statements in court and her filings, she does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any bond condition, she would just say no. And she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which she was out on bond for, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving, no license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so.
Okay. And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Everything. Yep. Yes.
Yeah.
The address I'm showing is 2214 Upward Falls Avenue, Latham.
Falls?
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Salaston, that is the issue before me is revoking or modifying your bond. If you will, I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond, reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she said that she won't have to come out, so I will bring her to you in person.
Okay, so she said she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, she'll come out. I mean, I'm glad to hear it's important.
Yes, sir.
So let's see whether or not she will comply this time.
Yeah. So it's an offer. Got it. Is it?
No, it's not. He had to get it.
All right, Celestine is with us. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authorities of the court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. I gotta make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be, once again, you should leave your bond where it is right now, which I think was, what was it, 20-some thousand? 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right, I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might as well just.
And you have a right to be heard on those issues, because that's the matter
Right.
right now.
Okay.
If you don't want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Ferretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond. And what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
Do you wish to respond to the bond criteria or not?
well, first, the bond is excessive, and I'm not supposed to have to be compelled to pay any costs until a conviction on a felony on a final trial. So that is my 17th guaranteed protection under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia. And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retaining rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to bond. Now we're back on.
I did give you Article
the bond conditions, yes or no.
I gave you Article 1, Section 1, Paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should, in Amendment 8, I should not be held under cause of imprisonment, under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. It's something else you're wrong about. But anyway, ma'am, I'm once again saying
I can adjust this comments and opinions posted on the record.
this is where I'll have you removed, because right now.
You might as well. That's fine. I don't care.
That's fine. But ma'am, you're clearly not going to respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part you're having it granted. You won't have to pay anything because you're not going to have anything to pay.
That's fine.
So
well, it's not for me because I'm not the defendant. I'm here with the defendant.
All right. Take care, ma'am.
Under be
We should
corrected.
make different decisions.
Arrest and coercion.
All right. Take care.
It's here for arraignment on two matters. They're all from the same date. They're all right. I see. So case number 3A 0257205, State versus Muhammad Idris. Charges vehicle operator refused to comply with the police officer. There are two infraction charges as well. 3A 0096934. It's violation of a special trip permit. And 3A 0096933. Failure to obey traffic control device and failure to renew his expired registration on a vehicle. Mr. Kale, any contact from Mr. Idris?
Either Mr. Idris or a representative of Mr. Idris is present on Zoom, Your Honor. And I believe he may tend to proceed pro se, or at least without the assistance of public defense. So I would ask the court to inquire with him about that.
I will. So on the screen listed as Muhammad, authorized representative for Muhammad Idris. Is that right?
First of all, I object to public defender saying that I'm pro se, which I am not. I'm the authorized representative on behalf of the estate. And I would like to request for continuance due to I made a request for discovery, and there was no email provided to me. And I was informed that only a phone number is available. And I called that phone number, and there was no answer. And I did not get any voicemail. And out of the 3 cases, I only received notice for 2. One is missing. I don't have the paperwork for that. Due for that reason, I would like to get a continuous.
All right, so let's start with this. Are you Muhammad Idris? Let's get the name straight to begin with.
That's the estate on the trust. I'm the authorized representative on behalf of the estate that the court is trying to administrate.
Well, the state's not charging the estate. The state is charging Muhammad Idris. So that's who we need to address. Is that you, is my question.
I object. If I have a question for, that's a question for the prosecutor, correct?
Well, you're here asking for a continuance because you want something else, I have to know who it is that is requesting the continuance and how you speak on behalf of Mohammed Idris.
I'm the authorized representative of the estate. Like my family name is Idris, given name Muhammad Ismail, for the estate, which is Muhammad Ismail Idris, estate on a trust.
All right. As I say, the estate is not being charged with the criminal offense. Muhammad Ismail Idris is being charged with criminal offenses. Now, you indicate that you only got 2 of the 3 notices. Which charges did you get notice of? Did you get notice for the failure to obey traffic signal?
I object to your saying this has nothing to do with the estate. It has everything to do with the estate and the trust that's being charged.
Well, not to be argumentative, Mr. Idris, but the estate wasn't driving the vehicle. I suspect the city or the state will try to prove that Mohammed Idris was driving the vehicle. That's their job in this case.
I object. That's a hearsay. The court is assuming and presuming that's the case, which is not. So if you can continue with the continuous, I'll appreciate it.
Well, I'm going to ask the city or the state rather to establish probable cause at this time on the charge ending in, or the case number ending in 7205, which is the vehicle operator refusing to comply with the officer. You've already been sworn, Ms. Mann, so we'll go ahead.
The charge of refusal to give information on May 11th, 2023, Officer Kelsler responded to a request for assistance from Officer Turner, who had performed a traffic stop on a commercial motor vehicle that was traveling in a left lane prohibited for CMVs southbound I-5 at milepost 96. The driver was later ID'd by his DOL photo on file as Mohammed Ismail Idris, and who
I object.
Both officers within the ID, despite multiple.
Mr. Idris, hold on, Ms. Mann. Mr. Idris, please let her finish.
Okay.
Let her finish. Go ahead, Ms. Mann.
Refused to provide both officers with an ID despite multiple requests by both officers. He was cited for operating a vehicle and refusing to comply with the police officer and released.
He was also charged with the infractions at that time?
Yes, Your Honor. And I have a probable cause for the special fuel trip permits violation as well, if you'd like.
Yes, why don't you give us that too?
On May 16th, 2023, Officer Turner observed a tractor trailer traveling south on I-5 near milepost 98, speeding and traveling in a restricted left lane. The officer made contact with the driver, who refused to identify himself, but was identified through his DOL photo on file as Mohammed Ismail Idris. While looking up his inspection history, it was revealed that the registration on the power unit had expired several months earlier and was revoked by the Washington State Department of Licensing. He was cited and released.
Is it my turn to speak?
All right, Mr. Idris, it's now your turn. Go ahead.
I object. I requested for continuous, and I was not informed if it was denied or granted. And I do not consent to being for the court to move forward. If you guys decide to move forward, I prefer physically present instead of a Zoom call. If you guys decide to continue.
And what's the basis of your objection again? Why you want a continuance?
The reason I need the continuance is out of the 3 cases, the case number, I only got 2 notices, not the 3rd one. One is missing. And also I requested for discovery to the clerk of the court. And they said, I have to get hold of the prosecutor office. And I got hold of the prosecutor office. There's no email for me to request for the discovery. The only way is a phone number. When I called the phone number, Nobody answered. So how can you guys continue without, I don't even have any discovery. So I don't know what's up against me. I don't have the details of the discovery.
Well, you've heard what's against you. Ms. Mann just repeated what she believes the state will be able to prove in this case.
There is not a proper notice.
Mr. Idris, hold on. It may be that the two infraction numbers appeared on the same document, case ending in 933 and case ending in 934, since they're both infractions. And then a second one would end in 205, which is a criminal charge. So that's a possibility. But based on your request to have this set over, we will set out the arraignment and you may appear in person. There's nothing stopping you from appearing in person.
Physically present.
Yes, in person. All right, although I believe there is probable cause been established, I'm not going to find that today to give Mr. Idris the opportunity to look at all these documents. And Ms. Mann, is there some better way for him to request the discovery in this case that he's talking about?
Not that I know of, Your Honor. I could check with my supervisor.
All right, go ahead. In the meantime, while we're looking for that information, Mr. Idris, I want to confirm a mailing address for you or for your estate. Let me check for a moment.
I object. I'm not a mister.
Pardon me?
I say I object. I want to make a correction. You called me mister. I'm not a mister. Mister is a title.
Is your address still on in Seattle, mailing address?
I don't have an address. I have a location, a private location I can only receive for mailing purposes only, for notices.
Is that a P.O. box in Tukwila?
That ends with
I'm seeing a P.O. box stated in Tukwila, Washington.
There's a dash at the end, 9998. There's 999 and 8. Those 4 digits is very important to put it on there.
So 8-888-9.
No.
I messed those last 4 up. What? What's next?
Like I said, I don't have an address. I have a private location where I can receive for mailing purposes only. And the only thing I will indicate is the last 4 digit after the end of the location, which ends 9998.
Is that a street address or a mailbox? Post office box.
That's my mailing location where I can receive notices only.
We can't address notice to you at 9998. I need more than that. What happens, Mr. Idris, is if you don't respond to this, there's going to be a warrant issued for your arrest. We have to give you notice first. That's what we're trying to get established here.
I object. Notices can be sent to me through my private email as well.
Are you going to give us that private email?
The court has it on file.
Your Honor.
Candace, do we have that?
Your Honor, good afternoon. This is DPA Tom Farrow. Before we proceed beyond this case, I'd like to address the court.
All right. I'm trying to get a mailing address here. Mr. Idris, we have 2 addresses from the Department of Licensing. One is on Avenue in Seattle, and the other is a P.O. box in Tukwila. If you're not willing to provide us with your email address, we're going to just send notice to those 2 addresses.
I object. Again, I'm going to make a correction. I'm not a mister, which is a title. If you can call me with my proper name, which is a family name and a given name, I'll appreciate that.
Yes, Mohammed Idris. We're going to send notice to those two addresses that we have.
You meant to say
Unless you give us
my
something different.
family. You meant to say my family name, which is Idris.
All right, we're going to use that. That's what he sent to us, requesting information about court, correct? All right, looks like we do have an email address for you when you
Your Honor,
requested
just before we go
information.
on.
All right, Mr. Farrow, let's hear from you.
Thank you, Your Honor. I was listening on the YouTube. I wanted to address the court just to highlight the fact that Mr. Idris was given the constitutionally required notice at the scene on at least two of these cause numbers. There are citations in the record. Those were handed to him, and he was advised of the upcoming court date. That's kind of my first point. So I think if the court wants to continue, I don't know when he was first scheduled for arraignment, but it looks like this has been going on for a little bit. If the court wants to continue on those two matters, I'm happy to. I mean, it says here, it's checked the box for the ticket was served on the violator. I'm happy. I guess I could send something to one of these email addresses, but I would also urge the court to note that if you look on Jabs, we've tried sending mail to Mr. Idris. It is not, or it's been returned. Finally, Your Honor, and I'm not trying to be silly about this, but I've sort of heard these arguments before in court, and I think I know where we're going with this. The state's not satisfied legally that the defendant in this case has appeared today. I think he's claiming to be some sort of representative for some sort of estate or trust or other nonsense. But based on Mr. Idris's failure to appear today, the state would request the court to issue a warrant in the amount of $10,000. Thank you, Your Honor.
I object. Everything he said is a hearsay, assumption, presumption, and tacit agreement. It has nothing to do with the facts. He's not telling the truth, the whole truth, and nothing but the truth. And he was supposed to take a stand and write an affidavit. He's not doing any of that. He's just waiting for my silence, acquiescence. So I object to everything that he said.
All right, I understand that. Mohammed Idris, he makes a good point. If you're going to argue that you are a representative for Mr. Idris, Mr. Idris hasn't made a full appearance in court yet today, and therefore that would lead to the potential issuance of a bench warrant for your arrest for not showing up. So can we resolve that question at least, that Mohammed Idris has appeared for arraignment today?
I object. Again, it's what you're saying. Everybody in the court is saying is assumptions, presumptions, tacit agreement is a hearsay. You cannot use a hearsay or assumption and presumption in court. It's wrong information, and I object to all of that. And I am not a representative. Like I said I am authorized representative or an agent or an executor of the estate on behalf of the estate and trust.
And as I've indicated, the estate was not driving this commercial vehicle at the time these citations were issued. So I'm not going to accept that. I'm not going to carry this on further, Mr. Idris.
Do you have a power of attorney for this matter to continue?
Do I?
Where's your power of attorney? Or the court, or yourself?
Mr. Idris, I'm going to find the following. If you'll listen, I'm sorry, Mohammed Idris, if you'll listen, here's what I'm going to do.
I object. I object.
I understand. Your objections have been noted. I'm finding probable cause today for the charges. I'm finding that Mohammed Idris did appear today, even though he argued and objected that he was appearing on behalf of an estate or a trust. I'm going to enter a plea of not guilty to these charges, and I'm going to set a pretrial hearing in this matter. Now, Mr. Idris, or Mohammed Idris, sorry, you may contact the prosecutor's office by writing. You have an email address that we have for you. We're going to send notice to the 2 addresses that Department of Licensing has and the email address that you used when you contacted the court of when your next court date is going to be. Mr. Farrow and Ms. Mann, I'll ask you to look for any contact from Mohammed Idris so that the discovery that he is requesting can be provided to him for his next court date. All right. We're going to set a pretrial conference for August 23rd at 2:30. I'm sorry, at 2 o'clock in the afternoon in this courtroom.
I object. If I prefer to be there physically present.
Come to court. You can do that. You do not have to be on Zoom. People come to court and have been here in court today.
That's why I asked for continuance. Why are you refusing my continuance? There is no proper notices. It's all based upon assumption and presumption in a hearsay.
You were given notice at the scene, as Mr. Farrow talked about on the infractions, and you were mailed notice.
That was not correct. Was he there? I was not given at the scene. He was not there. How can you accept his testimony? That's not, there's no affidavit, there's no witnesses.
Okay. Mohammed Idris, I'm not going to argue with you. I'm not going to argue with you about this. I can accept the sworn testimony of the officer who testified that he, in his citation, that he presented those documents to you on the scene of the stop. So if you want to continue to raise those arguments when you come back to court on the 23rd, that's fine. You can do that at that time. But we're not going to entertain any further arguments on that matter today.
I object.
I understand. And that's noted in the court record.
Your Honor, I hate to be a pain, but again, I know where this case is headed. I have to object on the record that the person who claims to be some part of a state or whatever does not appear to be a licensed attorney and is thus not authorized to make objections on the record on behalf of any other party. If Mr. Idris would like to proceed pro se, I would ask that the court read or go through the pro se colloquy with him, but otherwise I would ask that his objections not be noted. And I would renew my request for a warrant. Thank you.
I object
again.
Thank
you, Mr. Farrow.
I object again. What he said is not the facts. He's assuming.
Are you an attorney, Mohammed Idris? Are you an attorney? You licensed attorney in the state of Washington?
You haven't answered my question when I asked you, does the court have a power of attorney against this case? And all three of you guys refused to answer. And the prosecutor.
I don't know what that is. I don't know what it is that you're asking.
You don't know what power of attorney is? You have to have a
It's got nothing to do with the criminal case.
It's a civil, it's not criminal. Is it not?
No, these are criminal charges. At least one of them is.
Who's the executor of the estate?
Mr. Idris, you're missing the point. You're setting yourself up for more trouble. As Mr. Farrow points out, in order for you to represent yourself, you take a great risk in this case. And essentially, that's what you're saying you're doing.
Everything is a trust, is it not?
I don't know. I have only your testimony to that effect.
You're forcing me, without my consent, to administrate my estate without my consent. So I object to that gentleman. I want to get his name. Is he the prosecutor for this case? What's his name?
Yes, Tom Farrow. Can you see his name on the screen?
Tom Farrow. Is he the prosecutor for this case?
I'm going to assume so. He's here talking about it.
And I'm going to need the discovery from him. When I called, how come nobody picked up the phone?
Well, I have no idea who you called and what the situation was. All right. So I'm finding probable cause in the case ending in 7205, refusing to comply with the police officer. Ms. Mann, do you have request on
object, that's a
conditions of
hearsay.
release?
I object. That's a hearsay.
For both, the state requests personal recognizance with no criminal law violations, no driving without valid license and insurance, Your Honor.
I object. The fact is not being indicated onto the record. Are we even on the record?
We are on the record. All of this is on the record. It'll be there for you to review if you choose to do that.
Is everything being recorded?
Yes, it is.
Your Honor, the final thing I'll note for the record is even if this individual does reach out to the prosecutor's office, I'm not authorized to talk to a representative who's not an attorney, nor am I allowed to speak about a case with an individual who may or may not be represented and who certainly hasn't indicated that he intends to proceed pro se today. So I'm just at a bit of a loss.
I object.
Understand that.
I'm not the
Mohammed
decedent.
Idris, you're attempting to create a roadblock that there seems to be no way around. Mr. Farrow makes a good point.
Is he saying I'm the decedent? Is that what he's saying? Does he have a proof that I'm the decedent of the estate?
Mr. Mohammed Idris, are you representing yourself today in this case? Are you going to represent yourself on August 23rd when you come back to court?
It's impossible to represent myself, is it not?
No, it is possible. It's not necessarily a wise choice to represent yourself, but it's possible. Do you understand that you are, if you represent yourself, you are held to the same standards that an attorney is held to in terms of understanding the law and procedures of court if you choose to represent yourself?
I object again. Is the court using my bond? Where is the appearance bond and the bid bond? I do not understand. I do not comprehend, and I wish not to proceed.
Under those circumstances, Mohammed Idris, you should contact an attorney to give you some advice as to how to proceed in this matter.
I object. Where is my bond? I need my bond back. I need my bid bond. Or I'll write one and overnight it. Where is my bid bond? And who is the highest bidder of the case?
All right, on this case, State of Washington versus Mohammed Ismail Idris, case number 3A0257205 WSP, charges vehicle operator refusing to comply with a police officer. I'm entering a plea of not guilty to that charge. I am finding probable cause, first of all, on that charge. I am entering a plea of not guilty to that charge. It's obvious from Mohammed Idris's responses, he doesn't want to enter a plea of guilty to this charge today. We're not going to allow him to frustrate the procedure of the court by taking an irresponsible position like this. The conditions on your release, you are released on what's called your personal recognizance. That's your promise to return to court. Your court date is going to be August 23rd. We're going to send you notice to the two addresses that we have from the Department of Licensing and also to the email address that you contacted this court about. While you are waiting for that August 23rd court date, you are not to commit any new criminal law offenses, and you're not to drive without license and insurance.
I object.
Your next court date is going to be
I need more time. August 23rd is not enough.
There's plenty of time for court here. So we're going to do it on August the 23rd
I object.
at 2 p.m.
How can a trustee tell an executor what to do? Because I'm occupying the office of the executor.
This is not a civil matter. It's a criminal matter. I am not going to.
I am the executor and beneficiary of the trust. Am I not? You're the trustee.
I have no idea.
The prosecutor is the
Not
trustee.
an issue for this court. Mr. Ferro, I'm not going to issue a bench warrant today. I don't know how to answer the question that you've raised, which I think is a good one about your ability to provide response to Mr. Idris's request for discovery.
I'm not Mr.
I don't have the answer to that. So, Mr. Idris, you're able to get the order that I've just signed from the Thurston County District Court website under the cause number. Let me find it. 3A0257205. Your next court date will be the 23rd of August at 2 o'clock, and you are certainly welcome to be here in person on that day. Thank you, Mr. Idris. That's all for today.
Well, guys, we've come to the end of the proceeding for Mr. Muhammad. And as you can see, he constantly is saying some of the same things that we've seen sovereign citizens say in the past. And that's challenging jurisdiction, saying that he's the estate, constantly objecting. I don't know how many objections that he had on the record, constantly having to be reminded by the judge that this is not a civil matter, but it is a criminal matter. But as we can see, Mr. Muhammad definitely wasn't trying to hear any of that. And guess what? The judge wasn't trying to hear what he had to say either. Hopefully on his next appearance, he will, do the right thing, come back with a different mindset, which, more than likely we doubt that. But nonetheless, that's the end of this one. We'll be sharing the other one soon. And as always, guys, I appreciate you joining me here at Sovereign Citizens Hall of Fame. And with that being said, guys, for now, Sovereign Citizens Court is adjourned. I appreciate you guys, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.